Welcome and thank you for joining part 3 of Seyfarth's micro-webinar series, The Future Starts Now, Future of Work for New England Employers. This installment of the series will focus on impacts of technology on overtime exemptions. All participants are in listen-only mode. You are encouraged to submit questions throughout the program using the Q&A feature in WebEx. However, if your question is not answered, our presenters will follow up with you directly in the days ahead. For those interested in CLE credit, an attendance verification code will be read during the presentation. Please write this code down. It will not be repeated and is required for CLE credit. Copies of the webinar recording and materials will be distributed to attendees following the presentation. At this time, I'd like to turn the program over to Barry Miller. Barry, you may begin.
Thank you, Christian, and thank you for those folks joining us for this third installment in our series of webinars on the impact of technology on work in New England in particular. And today, Allison and I are going to focus primarily on the impacts of technology on the white-collar overtime exemptions to the Fair Labor Standards Act. So we can go ahead and skip to the next very informative slide. And there we are. My name is Barry Miller. Allison Silvera, Senior Counsel, is joining me. Both Allison and I are pretty active members of Seyfarth's Wage and Hour Litigation Practice Group. And what that means is we spend most of our working days defending employers from wage-related litigation, helping employers avoid disputes about the proper payment of wages, and also sort of keeping our eyes on the horizon for new developments that will become problematic wage and hour issues for employers down the line. And that's what this installment of our program is about. It really is about things that are on the horizon and coming towards us that you'll be dealing with in some number of years. You may think about it as sort of a ghost of Christmas future sort of scenario. And every time we do these webinars and we start to talk about potentially significant and mostly negative consequences that we see in the legal landscape, I always try to check myself because it's common for our constituents to say lawyers are always about to proclaim that the sky is falling. And I want to kind of adjust expectations about that there. I remember many years ago, the first time someone said to me that lawyers were overreactionary about these sorts of developments, it was in a program that we did probably before webinars were invented, when Massachusetts first adopted mandatory treble damages under its wage and hour laws. And at that time, I did a program with several of my colleagues, and I said, in the future, this statute is going to mean that we have plaintiffs' lawyers filing very opportunistic wage and hour litigation every time an employer makes a mistake and pays someone late. And in 2008, that was regarded as Chicken Little, sky is falling sort of paranoia. In 2022, it's just true. And we see it every day. And so that's kind of the horizon that I'm thinking about in terms of our presentation today. These are things that may not be here tomorrow, but will be here soon and likely for the rest of all of our working lives. So what you see here is just a very high-level overview of what Allison and I intend to cover. We're going to just provide a general superstructure for the Fair Labor Standards Act to provide some background here. And then we're going to go through several of these exemptions that we think are most likely to be impacted and most likely to be impacted soon by technological developments that are already beginning to crystallize in the commercial environment. Christian, can you take us to the next slide, please? So here's the background against which we are working in terms of the Fair Labor Standards Act and its exemptions. And one reason that we're focused on the Fair Labor Standards Act and those exemptions is that that statute really serves as the basis for almost all overtime and minimum wage regulation in the United States. While many individual jurisdictions have their own overtime requirements and their own exemptions, they're typically patterned to some degree on the Fair Labor Standards Act. And even if you look at a place like California that has a very unique wage and hour regime, a lot of the exemptions that you see there are still based on these very old ideas from the Fair Labor Standards Act, including the white-collar exemptions that we'll be talking about today. And that statute, the Fair Labor Standards Act, is a dinosaur. It was passed in 1938 which was the same year that the ballpoint pen was patented. We're talking about a statute that was literally written with a fountain pen or a typewriter. And there's been relatively little effort to bring that into the modern age. The Department of Labor is empowered to promulgate regulations that help to, or could help to, keep the statute and its requirements fairly modern. But that process is inherently cumbersome, and it's also a source of much disputes, many disputes and infighting among people who do wage and hour law for a living. And as a result, the law just is completely out of tune with the commercial environment that it seeks to regulate. We're dealing with a statute that was passed to regulate a widget factory in 1938, where your boss probably wore a tie with a short sleeve shirt and had a haircut that you could set your watch to and expected to be called Mr. So-and-so. And it's just not the modern environment, but we're dealing with exemptions that were created in that context and trying to understand what they mean in the modern context. So we can go ahead and go to the next slide, which we provide really just for background. This is just very high level stuff in terms of the general requirements of the exemptions that we'll be talking about today. So those of you who have a particular interest can look back at this later when we circulate the presentation, but we can go ahead and move on from this slide now. The first exemption we're going to talk about is the outside sales exemption. And in some ways, that may be the exemption that is most immediately impacted by not only future technology, but things that have already happened. And those aren't limited to new technologies that are emerging in the marketplace, but also the evolution of the marketplace itself, which in some ways is based on technology, and in some ways is just based on evolution in human interactions. But what the outside sales exemption requires fundamentally are two things. One, you have to have an employee whose primary duty is making sales. And two, that person has to be customarily and regularly engaged away from the employer's places of business. So they have to be making sales and they have to be outside. Simple as that. And prior to the pandemic, there was a whole class of people in the workforce whose job was focused very much on those functions. People who would travel around and undertake to meet with customers or potential customers and convince them to buy whatever it may be, software, pharmaceuticals, machinery. And it was very common to see these sales professionals out there in the world trying to get face-to-face meetings with people because they understood that that was the most effective way to engage in persuasive activity. And I think most folks would agree that it remains the case that an in-person conversation is going to tend to be a much more persuasive mode of communication than an email or a webinar or something like that. But the reality is people are just making less and less time to have those sorts of meetings with sales folks in particular. And that all came crashing down in the pandemic when many workplaces were closed, certainly not receiving visitors, and certainly not looking to have outsiders come into their workplace to try to sell them things. And almost immediately after the pandemic broke, we had clients coming to us and looking at their outside sales forces and saying, these people are still selling, but it's almost impossible for them to get outside with the level of frequency that may be required to meet this exemption. That level of frequency, by the way, is pretty modest. Customarily and regularly under the regulations has been interpreted to mean 1 or 2 outside meetings a week lasting 1 or 2 hours each. So it's not, certainly not a majority of the time test, and doesn't require that a salesperson be outside all the time. But when you have the combination of technological developments like Zoom and an environment in which people are just not meeting face to face anymore, we saw outside sales folks struggling to keep their appointment books full sufficiently to meet this exemption. Another thing that we see developing in this space is that the basis for this exemption is beginning to come into question. You'll see on the slide that's up on the screen now a fairly lengthy quote from an old case that I find myself citing often in court that describes why the outside sales exemption exists. And the reason it existed in 1938 was that a door-to-door salesman was very much a Willy Loman type character who would go out in the world and knock on doors and would not be within any line of sight of any supervisor who could keep tabs on that person, tell them that they were doing it wrong or right, and monitor their hours of work. In the modern environment, that's not really true. Most folks who go out in the world go out with one of these, and it's pretty easy to keep tabs on them, including where they are, what they're doing, and how much time they're spending on these tasks. And we do sometimes see the courts when they're looking at a potential application of the outside sales exemption, look at these so-called indicia of outside sales that are not part of the legal test, which includes only the two elements I've already described, but are the sorts of characteristics that outside sales folks tend to have. And we see people whose job is salesmen having those characteristics less and less. They're outside less and less, and they're relatively easy to monitor. And that may mean that you as employers will find it more and more difficult to justify continuing to treat these people as exempt. And you may face challenges from plaintiffs' lawyers contending that these once outside salespeople are now inside salespeople for the most part and are non-exempt. And one important point in that regard is that inside is an expansive concept under the outside sales exemption. So someone who's working from home, like I am today, is under these regulations working from the employer's place of business. They actually have to get out in the world to be outside. And we can see a continuing evolution of this technology. We now have companies out there that are designing retail stores in which there may be no employees at all, where transactions are monitored by computers with cameras and other technology, and there's no one making any kind of sale at all. In that regard, we have the outside aspect of the exemption potentially eroding, and we even have the sales aspect of the exemption eroding. And that too is not theoretical. We've had cases in the federal courts where plaintiffs take the position that even though their job was to go out and sell stuff to people, what they were doing was not making sales because they didn't process the transaction. They didn't take cash from the customer. They didn't run a credit card. Therefore, they're not making sales and they're not exempt. And there are three federal circuit courts who have chimed in on that issue up to this point. Two of them have found that persuasive activity continues to be the making of sales, even if there's no transaction processed by the salesperson. But one, the Sixth Circuit, went the other way and found that someone who's merely trying to persuade people to buy stuff but not processing transactions is not making sales. So this is one respect in which the future is very much now, and these technological developments that we see are really beginning to impact the application of the exemptions themselves. Let's go to the next slide. So the technology that relates to the outside sales exemption is really communications technology of the sort that we're taking advantage of right now. I want to talk about a couple of exemptions that will be impacted by a very different and in some ways much scarier form of technology, which is artificial intelligence and machine learning. There are a couple of exemptions that are based really on the exercise of human judgment. People making decisions based on usually a course of education and experience, all of which is premised on the notion that there's something special about somebody with expertise making a decision based on discretion and independent judgment. And we see that in the administrative exemption. Oftentimes when we're litigating the administrative exemption, what we're talking about is whether or not a given group of employees exercises sufficient discretion and independent judgment to meet that exemption. Similarly, with respect to the professional exemption that may cover things like scientists, for example, and lawyers, we have a requirement that people exercise consistent discretion and judgment in doing that work in order to be exempt. And against that age-old background, we have new tools coming into the workplace, computer-based tools that erode not only the necessity for a given employee to make judgment calls, but even their ability to do it. And we see this in the process development space itself. Those of you who are familiar with Six Sigma and Lean and those sorts of disciplines that are intended to make human work more efficient, recognize that one way to do that is subspecialization and routinization. Usually when you're trying to make something more efficient or more effective, one way you do that is remove as many discretionary judgment calls as you can. That's why pilots and surgeons have checklists, for example. And we see job aids beginning to come into play that really remake the landscape in terms of what judgment means. And I'll give you an example that brings this home to a significant extent. We've seen litigation with respect to a particular class of healthcare workers who do something called utilization review. And what that means is when you need some sort of medical service or your doctor believes that you need a given medical procedure, they submit it to the insurance company to approve. And historically, that request would be routed to a nurse or another healthcare professional, usually somebody that would be traditionally regarded as at least potentially exempt, as nurses are. And that person would look at the medical file, look at the procedure being requested, and then make a discretionary determination about whether that procedure was covered and appropriate under the plan. We now see computer-based job aids coming into that utilization review workspace that is causing plaintiffs' lawyers to contend that these people who have professional qualifications without dispute are no longer exercising discretion and independent judgment, because essentially what they're doing is looking through a medical file based on prompts from a computer, determining whether particular terms or tests appear in the file, populating that into a form in the computer, and then they literally get a green light or a red light. And that is the decision about whether or not you're going to get that medical procedure. And the plaintiff's lawyers have argued that once you have a tool like that, the human is no longer making a discretionary decision. And up to this point, we've defended those cases effectively, but you can see how the continuing development of technology would potentially erode that defense in the future. And of course, that's not limited to utilization review. It could touch many different types of workspaces. There's an article in the Harvard Business Review that just came out recently about the application of very new technologies that will draft written work product for you. One of them is called ChatGPT. And another concept that's very much related to this that you will see in the media as well is artificial intelligence supported stable diffusion. And with either of these software products, you can give a simple instruction to a computer and it will generate what appears to be creative and or discretionary work product. You could tell it to draw a picture, you could tell it to include certain colors, certain objects in a picture, and the computer will just spit that out. And that has potentially two ramifications. One is on the notion of creativity. So up to this point, I've been focusing on discretion and judgment. There's another type of professional exemption that's recognized under the Fair Labor Standards Act, which is called the creative professional exemption, which applies to things like journalists who may be writing stories from scratch and graphic artists who may be painting from scratch. Similarly, I've already mentioned ChatGPT. Now that we have computers that can essentially engage in the creative process, whether or not a given employee is exercising that creativity or that discretion becomes more subject to question every day. And here we come to one of those Chicken Little moments. Do we really believe that computers are going to be able to replace, say, the professional judgment of a lawyer or a nurse or the creative capacity of a composer? So let's take a look at the next slide. This is an example that I just did this morning. I asked ChatGPT, tell me about the impact of technology on the Fair Labor Standards Act white-collar exemptions. That is the subject matter we're discussing here today. I'll let you read the example for yourself, but this was something that was spit out in about 20 seconds and does a pretty good job of capturing not only the background. I didn't tell it what the Fair Labor Standards Act was about. I didn't tell it what the exemptions meant. It figured that out itself. But it actually has some fairly insightful things to say about how technology could impact the exemptions, including one I hadn't thought of before, which is it may render some of the exemptions moot for some people by making their work more efficient. If you're able to get 46 hours of work done in 39 hours, perhaps you're not going to cross an overtime threshold for a week. Now, I don't want to get too far into that because I think the tendency of employers when folks figure out how to get their work done in 39 hours is probably going to be to give them more work to do. But I hold this out there as an example of technology that exists now. This was created this morning, and what you see was not refined or edited by me or anyone else at all. And when you see something like this, you can really begin to feel the impact of these technologies on what traditionally are thought of as very human functions. And when you layer onto that the exponential rate at which technology develops and things that we are seeing out there on the horizon, like quantum computing, the technology behind something like ChatGPT or Stable Diffusion is going to continue to develop at an extremely rapid pace. And it's going to get better and better at doing this to the point where it's going to become blurry when you're using a computer as to whether you're even dealing with a human or dealing with automated content. And that's the point at which your Fair Labor Standards Act exemptions very much may come into question. So with that doom and gloom, I'm going to go ahead and pass it over to Allison to give us the CLE code and cover a few more of the exemptions.
Thanks, Barry. So the CLE code is SS7103. That's S as in Sam, S as in Sam, 7103. Perfect. Thanks, Christian. So picking up where Barry left off, I've now learned that my next legal brief, I'll start with ChatGPT, but putting that to one side, we wanted to talk for a few minutes about the executive exemption. The requirements of the exemption: an individual must, among other things, customarily and regularly direct the work of 2 or more employees and must have the authority to hire or fire employees. In 1938, it's safe to say that we didn't have the type of global economy that currently exists. And between time zone challenges and now the challenges of a hybrid, remote, or in-person workforce, the question of who's directing an employee's work is likely muddled. Up until now, directing the work has been interpreted by most courts as meaning or equivalent to supervise. So if you supervise 2 or more full-time equivalents, you may qualify for this exemption. But what about where an individual's work for a day is generated by a computer? They come into the office, there's something printed out, these are the tasks you need to complete today. When that happens, we start to wonder who is directing the work. Even if you're supervising, if you're not telling people where to go, you may not qualify as directing the work. And similarly, when we consider who is supervising an employee, we often look to who completes that employee's performance evaluations. So as good evidence of who the supervisor is, the person who's collecting and giving feedback on a day-to-day or month-to-month or quarterly basis. But there are lots of industries now where performance is measured based exclusively or almost exclusively on productivity. So the faster or more efficiently you deliver a package, you might get a bonus. The more accurately you perform your work, you become eligible for the next or bigger assignment. So where performance is equated with productivity, and productivity is measured based on AI or predetermined algorithms that have nothing to do with the individual employee himself or herself who is supervising. So all of that is to say, so far we haven't seen a lot of challenges on this issue of who's directing the work under the executive exemption outside of the context of supervising, but we anticipate they're coming, and that this could impact for businesses that have really embraced technology, embraced the productivity standards, embraced the sort of idea that an employee's day-to-day work can be automated from another location and then spit out at the location where the employee is working as sort of the tasks to do for the day. It could impact the exempt status of people who would otherwise fall squarely within the exemption. Your highest of highest executives in the company may no longer be customarily and regularly directing the work of anyone if it's being left to technology to sort of have that impact. And similarly, AI has also has implications that we've started seeing in the third prong of the exemption, which is, does an individual have the authority to hire or fire, or their recommendations for hiring or firing get taken into account? And again, related to just what we just discussed on supervision, what if termination decisions are based solely on productivity based off of a predetermined algorithm? Does that remove the authority to fire from a manager? What if the manager has no ability to override determinations that are made based on productivity? It puts you in a circumstance, and similarly, it's hire or fire in that prong, but we've seen AI increasingly being used in the hiring process. It can be used to screen applicants. It can predict who will be a good employee based on the qualifications in somebody's resume. And this might be more efficient and arguably help plan for a more qualified or productive workforce. But if you're going to rely on AI to make hiring decisions, is it removing the ability to hire from a manager? And you could find yourself in a place where that manager has no real involvement day to day in the hiring or firing process. And so all of this is to say we expect these types of uses of technology to be challenged in the exempt status, perhaps sooner rather than later. Barry skipped over one of the slides, but we are waiting for new regulations concerning the exemptions, the overtime exemptions from the Biden administration. We expected them in October. We haven't seen them yet. We expect they'll impact the salary threshold for the white collar exemptions. They may also have some changes to the sort of substance of the exemptions themselves. But the best advice we can give right now is to maintain the human component of your workforce. And that means don't cede all supervisor responsibilities or hiring or firing responsibilities to the results of a test. Ensure that managers from the highest level all the way down to the store level managers and assistant managers have a role in these processes. Because efficiency in the end may not be the best solution if it's not coupled with meaningful oversight of the employees who report to you. And I think there's a lot of inclination and sort of awe as we look towards what these technologies can do, including what Barry just showed us that these technologies can do. But remembering to maintain the human piece of it will be important for the executive exemption, and I think the administrative exemption that Barry just covered as well. Christian, last slide. So the last exemption we wanted to touch on is the computer exemption. There is a computer professionals exemption. It was put into the regs in the early 1990s. And one of the questions we get a lot when we're taking a look at a workforce, helping to audit whether people are properly classified as exempt or not exempt, is this person uses computers all the time, so they probably qualify for the computer professional exemption. The reality is a significant portion of our workforce relies on computers and computer systems to perform our jobs day in and day out, probably 1,000% more than we did in 1990 when the internet had just been invented. Email wasn't universally available, and the vast majority of people still worked in pen and paper. The idea of networked shared folders, everyone having a laptop, was still decades in the future. So now that we're in that place where we all use shared folders, we have the ability to change network settings on our computers. We can independently manage and run remote video conferences. We can troubleshoot our own issues like why the printer won't print. Should the exemption be more universally available? And the short answer to that is no, not as the exemption is currently contemplated. While it's commonly referred to as a complete computer employee exemption, that's really almost a misnomer. The focus of the exemption is not computer users. It's the most sophisticated and technical network designers, architects, and engineers. So and the DOL opined several years ago now, but that even the people who regularly troubleshoot computers for individual users or even across networks are not likely to qualify for the exemption. There hasn't been a lot of litigation around who can qualify for the exemptions, but the courts that have interpreted have stuck to a very strict reading of the text of the exemption itself, which is that it must be somebody who's employed as a computer systems analyst, computer programmer, software engineer, or similar worker in the computer field. And the primary duties must relate to systems analysis techniques and procedures or the design and development of computer systems or programs. So one court even found that if an employee can resolve the issue by phone, they don't meet the exemption, that the exemption is designed for people who resolve issues that take weeks or longer I don't know exactly what that means, but it sort of starts to tell you the significance of the level of employee that the courts are interpreting the computer professional exemption to apply to. And in reality, the reality of it is that the heyday for this exemption was probably in the early 2000s, when companies were developing their networks and network-related policies and infrastructure. And now we're on the side of using it much more judiciously and recommending that you use it much more judiciously, because the everyday IT folks who comply with and manage those policies, or even add some new features to a network in order to update it and keep it relevant and current, may be at risk if their exempt status is challenged. That pretty much is what we wanted to cover for today. I'm not sure, Barry, if you have any closing remarks.
No, not in particular. Thank you to those of you who joined us. If you have questions about any of the material that has been covered here, either the specific exemptions at issue or the impact of technology on wage and hour compliance more generally, of course, feel free to reach out, and also keep an eye out for additional blog posts on this subject matter and further installments in our webinar series on technology and the workplace in New England. Thank you for joining us.
Thanks, everyone.